answering problem and essay questions on the selected topics. For example, if you have to answer 3 questions on the exam, you can revise 3 topics or 4 topics just to have one as a backup. Or if you have to answer 2 questions on the exam, you can revise 2 or 3 topics. So you do not have to study everything that you covered on your degree. You can only study as many topics as you're required to do for the exam purposes. Practice answering problem and essay questions. This is very important. I've seen a lot of students try to learn everything by heart and do not practice before the exam. This can have very bad consequences. Knowing the law is like 50% of the work, and knowing how to answer, how to apply that law to the facts of the case in the problem question, or how to apply your legal knowledge in an essay question, that's another thing. That's another 50% of the work that you have to do. So make sure that you practice as much as possible before going to the exam. And finally, you should follow your professor's guidelines. On the lecture, they give you a list of cases that you should be revising, and make sure that you know these cases that they give you on the lectures. Follow the right structure. Problem and essay questions have very specific structure. It's called IRAC structure, issue, rule, application, and conclusion. So the arguments that you make in the problem and essay questions should be following this structure. You have to first discuss the relevant law, and then you have to make an argument. If it's a problem question, you have to apply the law to the facts of the case and make an argument about advise the parties of whatever they're asking you to do in the question. If it's an essay question, then you have to make an argument referring back to the question asked. Always answer the question. Make strong arguments based on the relevant law and always relevant within the scope of the question. It's a very common mistake that students make, that if they see an essay question is, for example, asking about Consumer Rights Act, they just write everything they know about Consumer Rights Act instead of answering the question asked. You should not make this mistake. You should show good knowledge of the relevant topic, but always answer the question asked. If you have to, read it many times and make sure that you understand what they're asking you and make your arguments relevant to the question. Today's topic is Consumer Rights Act and exclusion clauses. We have an example problem question that we are going to answer now. John purchased 5 bottles of brandy and arranged their delivery through Parcel Delivery Ltd. John has worked with them before, but has not dealt with them for a long time. Later, the company confirmed the receipt of his order by email referencing their website's terms and conditions. Despite the difficulty in locating the terms and conditions on the website, John managed to find them. This condition stated, Parcel Delivery Ltd. accepts no liability for death or personal injury, howsoever cost. The liability of Parcel Delivery Ltd. is limited to £500 for any damage, howsoever cost. Upon querying about these clauses, John was assured by the company not to worry, as they were intended to cover their liability in case they did something silly, but that never happened. The subsequent day upon receiving the delivery, John found that most parcels were broken due to an accident involving the delivery van, which occurred because the driver had fallen asleep. In the process of unpacking, John sustained cuts on his hands from the broken glass. John seeks advice on his rights and potential remedies against Parcel Delivery Ltd. So as you can see, the question is asking you not only to advise John about his rights, also about remedies. So make sure that if you have a question like this, you advise on both his rights as well as remedies. The first legal issue would be to discuss if the exclusion clauses are incorporated in the contract. A clause can be incorporated in the contract through a consistency in course of dealing, but it is difficult to establish. So just to elaborate on this point, you have to not only say what is the law, the relevant law in this case, but also cite the case. Even if you remember that this is the law, you have to always cite the case because you are advising John, and you have to advise John based on the law as it is of now, and you have to obviously cite the relevant laws, otherwise your argument will not count towards your grade. John has not dealt with Parcel Delivery Ltd for a long time, therefore it is unlikely that the exclusion would be incorporated in the contract through this method. So after you said what is the relevant law, you have to apply it to the facts of the case and advise John, how is this law going to affect John's situation? What would be the outcome? Second legal issue, has John been given sufficient notice of the terms? There are 3 requirements to consider for the exclusion clause to be incorporated in the contract. This is the second issue. Providing notice before or at the time of contracting, again citing the relevant case, Thornton versus Shoe Lane Parking. The second requirement, the clause being within a document with contractual effect, Chapelton versus Barry, taking reasonable steps to ensure parties' awareness of the clause, so the party knows about the existence of the clause, and the case you can cite is Interfoto. Apply the law to the facts. After you set the requirements, then you have to apply to the facts. In John's case, he was informed about the terms after the contract had been established later that day. Therefore, the first requirement is unlikely to be satisfied because he was informed later. Similarly, the second requirement might not be fulfilled because the existence of the terms and conditions was in the email receipt. And we have a case, Thornton versus Shoe Lane Parking, where it was argued that receipt is not the document with contractual effect. Therefore, relying on that case, we could argue that this email was a receipt of his order. Therefore, it cannot count as a contractual document. However, the third requirement could potentially be met as the terms were mentioned on the website, which John found and inquired about. He was definitely aware of the terms because although it was hard to find, he did find it, and he even called about it to them, and he even asked about it. So there is no doubt that he was aware of the terms. Considering that the first 2 requirements are doubtful to be met, the exclusion clauses may not be integrated into the contract. Then the next legal issue to discuss would be if they can restrict the liability for personal injury. This is a B2C contract. John is a consumer in this case, and the business to consumer contract. The relevant section from Consumer Rights Act 2015 would be section 65(1). Liability cannot be excluded for negligence which resulted in personal injury or death. Applying section 65 to the facts of the case, Parcel Delivery Ltd cannot restrict liability for personal injury. This case, John had his hand because of the broken glass, and they cannot exclude liability for personal injury if it resulted from negligence. But then there would be another discussion to show that it was negligence. How did that happen? The boxes that got delivered to John was in a van that was in the accident because I believe the driver fell asleep. So that could be negligent driving. And then the fact that nobody checked those boxes and that it was broken and it was delivered broken, that could also be negligence. Therefore, you can argue that their conduct was negligent and they cannot exclude liability for personal injury because of their negligence. Can they limit their liability to £500? That's another issue. There is something called unfair terms, and unfair terms are not binding. That's section 62 of the Consumer Rights Act 2015. Terms that are transparent and prominent are excluded from the test. Test of fairness. So there is a test of fairness that this clause has to go through. And if the court says that those terms are fair, then the clauses will be effective. Well, they did include it in the terms and John looked at it, but would you argue that it was transparent and prominent? Well, it was really hard to find the terms and conditions on the website, so that can affect the transparency argument. Also, it can be argued that limiting the liability to £500 is unfair because they were dealing with expensive goods and the test of fairness could fail on this basis. You can see the full answer on our platform, but we have now reviewed the main legal issues in this problem question, and I have given you detailed guidance about what you should argue. Please have a look at our contract law study materials on our platform. We have revision notes on all the main topics of contract law. We have case summaries, model essays of Height 1 and first class levels, and you should review them. Quizzes to practice your knowledge, tutorial videos like this, and animated videos as well. And we have flashcards. Now I'd like to briefly give you an overview of our services and how we can help you. We are a team of content creators and tutors. We are law graduates. We achieved high grades in our law degrees. We are from different English universities, such as LSE, City University of London, and so on. We are not associated with these universities, but we hire their best graduates. In addition to the ready-to-go first class study materials that we provide, we have tutoring as well for personalized support. Most of the students need tutoring in addition to the study materials to achieve high grades, and we strongly recommend that you get the tutoring service at least before your exams to maximize your chances of achieving high grades. During the tutoring sessions, you will have a one-to-one meeting with the tutor, and the tutor will answer all your questions, obviously, and you can practice answering any problem question and essay question that you want. It's tailored to your needs, so you can tell the tutor which question you want to answer, and the tutor will help you with that question specifically. As you can see, we have helped thousands of students get high grades. We have a lot of reviews that you can check out. Thank you very much for your attention.